Hi, everyone. Thank you for joining me today. I am attorney Jamila Little, and today I want to discuss with you a fairly recent Supreme Court ruling that will be helpful to those of you who are in removal or deportation proceedings. That case is Niz Chavez, and it deals with the stop time rule. So take a look at this video. It is going to be a longer video because there's a lot to explain, but it can be helpful, like I said, for those of you who maybe have been living in the United States for a long time, and you don't have any criminal background, no criminal issues, and you find yourself now in deportation proceedings. So thanks again for joining. Take a look at this video. Okay, guys, so as I mentioned before, we're going to be talking about Niz Chavez in this video. It is a recent Supreme Court ruling that just came down earlier this year in 2021. All right, so it dealt with issue of the stop time rule and removal proceedings. So let's start with talking about what the stop time rule is. So in removal proceedings, you let's say you're someone who is a non-permanent resident and you find yourself in removal proceedings. If you have been here in the United States continuously for at least 10 years, you have no criminal record, as I discussed before, and you meet some other qualifications, you may qualify for a discretionary form of relief called cancellation of removal. So non-LPR cancellation of removal may be something that you qualify for. However, the stop time rule is a rule, and I'm going to just break it down really basically. It's a rule that says if you received an NTA prior to those 10 years passing, it's going to stop the time. So it's going to put a pause on that 10-year period that is needed for you to qualify for this cancellation of removal. So in effect, what it does is if you receive an NTA, a notice to appear in immigration court, and I have done other videos on NTAs, I'm going to link it in this description, the description for this video, because it's important to understand what an NTA is. So if you have received an NTA prior to the 10 years elapsing, then it stops the time period and you no longer qualify for cancellation of removal if you are placed in immigration proceedings. It is important to understand what an NTA is, or a notice to appear is, because that is actually the basis of the ruling that the Supreme Court actually had in Niz Chavez. So the holding, or the ruling that the Supreme Court had in that case, says an NTA sufficient to trigger the stop time rule, we just spoke about the stop time rule, is a single document containing all the information about an individual's removal hearing specified therein. So that's important to note, because what was happening, and there's several other cases that came before this case, but what was happening is that DHS would issue an NTA, or notice to appear, to people in removal proceedings, or to place people in removal proceedings, and that NTA would not contain all of the information that was needed. Specifically, it may not contain a date and a time, and we would see a lot of NTAs with a TBD, to be determined, on the NTA as far as the date and time for the proceedings. And that became an issue for people who would have otherwise qualified for cancellation of removal. Because of the stop time rule, they would not qualify if these NTAs that did not have sufficient information were considered NTAs. So what are the things that must be on your NTA? So your NTA must have the allegations against you, the nature of the proceedings, the address, time, court for where your proceedings should be held in order to be valid. So take a look at your NTA if you are in removal proceedings. If you have an NTA that does not contain all of this information, then what the Supreme Court is saying in this new case is that your NTA is not valid and you actually may still qualify for cancellation of removal. So that was a lot of information there, guys. And I want you, if you may be in this situation, to find yourself a good immigration attorney to take a look at your NTA and to analyze the charges against you and see what options you may have. Who knows? You may qualify for cancellation of removal. The stop time rule may not be something that affects your case, but again, seek out the help of a good immigration attorney to determine these things. All right. Thank you again for watching this video. I hope it was helpful to you. Be sure to like and share with someone who you think it would be helpful for, and I will see you in the next time. Bye, guys.